Assalamu alaikum.
Good evening, everyone. I, Saqib Rahman, Senior Lecturer at the Department of Law, North South University, would like to welcome you all to our webinar today. It would be an absolute pleasure on our part to be able to listen to Professor Jennifer Trahan, who has kindly made the time to talk on the topic Vetoes and Atrocity Crimes, the use by a UN Security Council permanent member of its veto power. Before we request Professor Trahan to start, I would like to bring to the notice of the listeners that the chat box is open, and any questions you are welcome to make any questions in the chat box. The audience is requested to please keep their microphones and your cameras off. And lastly, I would extend my thanks on behalf of the Department of Law to all of you here. It is unfortunate that due to technical issues, we are unable to get an audience of more than 100 this time. However, we are trying our best to work with the IT, and I'm sure we will be able to fix it very soon. And of course, you'd be glad to know that this is going on record, and we will be uploading this on our YouTube channel. Now, introducing our guest speaker, Jennifer Trahan is a clinical professor at NYU's Center for Global Affairs, where she directs their concentration in international law and human rights. She has published scores of law review articles and book chapters on topics of international criminal law and international justice, including on the International Criminal Court's crime of aggression. Her book, Legal Limits to Security Council Veto Power to the Face of Atrocity Crimes, a Cambridge University Press publication of 2020, was awarded the 2020 ABILA Book of the Year Award by the American branch of the International Law Association. She serves as one of the US representatives to the Use of Force Committee of the International Law Association and holds various positions with the American branch of the International Law Association. She additionally served as an amicus curiae to the International Criminal Court on the appeal of the situation regarding Afghanistan and serves on the Council of Advisors on the application of the Rome Statute to cyberwarfare. Before listening to Professor Trahan, I would like to request Professor Mohammad Rizwanul Islam, Chair of the Department of Law at North South University, for his introductory remarks.
Thank you, Saqib. Good morning to Professor Jennifer Trahan. Good evening to my esteemed colleagues and dear students and respected members of the audience. First of all, I would like to extend my sincere thanks to Professor Trahan for agreeing to speak for us on such a short notice. She has been very gracious to respond to our request. I have not had the pleasure of reading Jennifer's book, but I have had the pleasure of reading her Case Western Reserve Journal of International Law's article published in last year, which I think in a way is a very good preview of her CUP book that Saqib has just mentioned. Many realist legal scholars dismiss us, the international law students, that we deal with issues which are divorced from the realities of the world. I don't think Professor Jennifer's scholarship can be dismissed in such a way. She has dealt with a question which impacts all of us in one way or the other. And she has, I think, made a very compelling case which cannot be easily brushed aside. If we have a look at the Charter of the United Nations, we would see, even at the preamble, there is a clear reference that the UN would work for world peace and security. I would think that it would not be unfair to claim that most observers of international law, international relations, and political commentators would agree that the UN Charter's mandate has not really been fulfilled to the way that we would have liked to have seen. I cannot say that the veto power is the sole reason for this, but I would think that the veto power has somehow played an instrumental role to this. And as Professor Jennifer has shown in her work, that you or I would be discounting the numbers if we just look at the number of times when veto power has been exercised. We should rather consider on how many occasions the threat of a potential veto power has meant that either the sponsors of a proposed resolution has backtracked or has somehow watered down the resolution, which has meant that the Security Council could not act the way that it should have acted. So with that note, I thank you all once again for your gracious presence. And like most of you, I eagerly await Professor Trahan's lecture. Thank you for your company. Thank you.
Thank you, sir. I would now like to request Professor Abdurrahman Khan, Dean of the School of Humanities and Social Sciences at North South University, for his introductory remarks. Please, sir.
Yeah, thank you, Mr. Chakib, and thank you, the Chair of the Department of Law. I don't want to stand between the Honorable Professor Jennifer Trahan and the audience, because you all are eagerly waiting to listen to the professor about the veto power of the Security Council and what has been the impact of that on atrocities in the world around. But in any case, heartiest welcome to North South University, the first private university in Bangladesh. It was founded in 1992. I will not bore you with the details of the history of this university, but I must tell you that this university, not only the first in terms of historical origin, but also in terms of its ranking, in terms of its performance, in terms of number of students, faculty, and number of PhD faculty. I think this stands out as not only among the private universities in Bangladesh, but also it ranks very well with the public or government universities in Bangladesh. So we stand out and we welcome you once again to North South University. And we are very happy that this is an occasion. In fact, Corona has given us this opportunity. It has forced us to resort to this kind of low cost methodology of interaction and academic interaction. So I would expect that even when Corona is gone, I don't know when it will be gone, nobody can say that, but even if it is gone, I think this low cost, low logistics methodology of interaction should be retained and it should be expanded further. The kind of program that we have initiated today with you at the Department of Law, I think this should branch out to other areas like exchange of faculty, exchange of students also, so that we interact more, more frequently, and that becomes constructive and also rewarding for not only the faculty members but also for the students. I'm not a person of international law. I will not be understanding much, but what I would just interrogate one issue, and the issue is basically, we know that law should be the highest position, but unfortunately, when it comes to Security Council, particularly where power matters, politics matters. In fact, politics goes to the highest position and law takes a secondary position. Now, this is where I think whether is there any kind of, can we have some dialogue with the civil society, international civil society, and also non-governmental organizations who work with humanitarian issues, and then raise voices so that, as Rejwan was saying, that sometimes it has some impact on the, the gravity of the, resolutions that are posed. So that kind of dialogue should be initiated, and this meeting today probably could be one of the. So with this, in fact, again, let me welcome you and thank you very much. I will all look forward to your very constructive meeting today and your delivery today. Thank you very much.
Thank you very much, sir. Now, the talk that you've all been eagerly waiting for, Professor Jennifer Trahan, you may please start whenever you're comfortable.
Great. Thank you so much, and thank you for inviting me. I never thought I would be launching my book in Bangladesh. So you're right that COVID has brought a few good things, only very, very few. But, this is one of them. And thank you so much for those kind introductory remarks, and Professor Rizwan for inviting me. It is a great pleasure to be able to speak at North South University. So my discussion will focus on the use of the veto by permanent members of the Security Council in the face of atrocity crimes. So I use the phrase atrocity crimes to mean genocide, war crimes, and crimes against humanity. I'm going to organize it in terms of discussing a little bit of the history. Where does the veto come from? Then I will talk about how the veto has been and is being used while there are ongoing atrocities. I'll then talk about the current approach that we've been taking, which is basically I'll call voluntary veto restraint. Would the permanent members please voluntarily restrain themselves, which I will argue is not working. And then it will come to my legal arguments that international law has something to say about this. So starting back in the early drafting period of what became the UN Charter, we see a strong Soviet Union insistence on what they were then calling the principle of unanimity. And this, of course, becomes the veto power. And interestingly, the US and UK took the view at the negotiations at Yalta and Dumbarton Oaks that, well, if there is to be a veto, certainly if the permanent member were involved in the situation, the issue, the permanent member should not have the veto. And this was a point of contention between, and the negotiations seem primarily to have been conducted between the US, UK, and the Soviet Union, with China somewhat involved and France being added as a permanent member late in the day. In the end, the US, UK gave in to the Soviet insistence of a broad veto power, at least under Chapter 7, and there would be no carve out, even if the country were involved in the situation. And just imagine how things might have turned out differently if they hadn't given in on that point. When the negotiations go to San Francisco, to the War Memorial Opera House, the other states also push it back against this veto power, and various limitations were suggested, but they didn't prevail. And here the assumption seemed to be, if the permanent members were to be the major troop contributing powers, and again, this has not exactly turned out to be the case, then they should have this extraordinary power. So there was a broad veto power given in 1945. I would argue even in 1945, it wasn't unlimited, because we see it is framed within the UN's purposes and principles in Article 1, and Article 24.2 says the Security Council must adhere to these. And already in 1945, there were nascent notions of jus cogens. What would the drafters make of current veto use? We don't know. The system of international justice didn't yet really exist. So a veto of a chemical weapons inspection regime in Syria, what would the drafters have thought? They did not reach these issues. Then, of course, you all know in the Cold War, there was extensive veto use, predominantly by the US and Soviet Union, related to their spheres of influence. And interestingly, we see our earliest call for veto restraint in 1946. 1 year after the charter was signed, the General Assembly in a resolution is requesting the permanent members to show moderation in their use of the veto. And there is genuine fear that the whole UN structure, the Security Council, will lapse into the dysfunctionality of the League of Nations. We have a series of these early resolutions calling for veto restraint, and they manifest in the 1950 Uniting for Peace resolution, which allowed for the calling of an emergency special session in the General Assembly if the Security Council was paralyzed. And the US wanted to get the vote to the General Assembly. It was a differently composed General Assembly because it was thought it would be sympathetic at a time the US was seeking authorization for the Korean War. The process under the Uniting for Peace resolution has only been used 11 times, so it certainly isn't a full solution to the veto paralysis, and it isn't being invoked today. Coming out of the Cold War, of course, I think in the 90s, we have a brief period of optimism that we won't have US and Soviet, that then of course Russia assumes the seat. We won't have all of these offsetting vetoes. And indeed, in this period of time, the Yugoslav and Rwanda tribunals are created and a variety of peacekeeping operations authorized. But I would suggest we're somewhat out of that period of time. And we're back to maybe hearkening back to some of the overtones of the Cold War in veto use. So let me give you some examples of what I'm talking about. During the dismantlement of apartheid, the Security Council has a variety of measures, and they eventually ratchet up to mandatory sanctions. But it's a long and slow process, and the US, UK, and France are using their veto power. And it probably delays the dismantlement of apartheid, under which, of course, there were significant fatalities. During the Rwanda genocide in 1994, there's no actual veto, but these same 3 permanent members refused to let the word genocide be used because it is was considered there might be obligations. They should be doing something if they use this word genocide. And of course, this contributes also to the inaction of the Security Council. We also see relative passivity of the Security Council in the face of horrifically large-scale atrocity crimes in Darfur, Sri Lanka, and Myanmar. And here it is more the veto threat. And the veto threat blocks the Council just as effectively as an actual veto. The measure simply cannot pass. And what we see, for instance, in Darfur, and my book contains a chronology of the atrocity crimes in Darfur and the veto threats that weaken the sanctions that other members of the Council were ready to impose, weaken the mandate of peacekeepers, and delayed the deployment of peacekeepers. All the while, we have genocide, war crimes, crimes against humanity being committed, and a death toll of around 450,000. We see a similar passivity out of the Security Council during the horrific fatalities in Sri Lanka. And again, we have this in Myanmar. Myanmar, there was one actual veto in 2007 that would have early on condemned the crimes. And the problem is, if you can't even condemn the crimes, you know the Council is not going to be able to ratchet up to other measures. And it, in effect, can then give a green light to perpetrators on the ground that they have a protector on the Council. Our most dispiriting recent huge set of vetoes has been related to Syria by Russia, and sometimes Russia and China, a double veto. And my book, again, does a detailed chronology of the crimes. We see all the crimes accelerating, and we have vetoes of a series of resolutions that would have condemned crimes. Then we have veto of referral of the crimes to the International Criminal Court. Then we have 6 vetoes related to chemical weapons that would have imposed various measures to try to restrain chemical weapons use. And these get vetoed, including a joint investigative mechanism that would have attributed responsibility to the side using the chemical weapons. And it's important to note that when this mechanism starts, we actually see a decline in veto use in chemical weapons in Syria. And then we have the veto of the joint investigative mechanism, and we have more chemical weapons. So I think there we see a direct correlation between the veto on the East River and fatalities on the ground. We even have the blocking of measures designed to provide humanitarian relief. So I think all put together, we can make a strong case that the way the veto is being used is costing lives on the ground. So how has the UN system been responding? Well, I mentioned these early resolutions calling for veto restraint, and this has been the path more recently as well. They start off in the more recent terms in 2001, the report of the International Commission on Intervention in State Sovereignty. Under the auspices of Canada, they convene these experts, and this is our first report that coins the term responsibility to protect. Now, within the report on the responsibility to protect, is a call that there be restraint in veto use, because already then they recognize that R2P can be all too easily blocked by the veto. And if people are asking, well, where was R2P in all of the situations I've discussed, Darfur, Sri Lanka, Syria, Myanmar, it was either blocked by the veto or the veto threat. So the agenda of R2P is being blocked. We then have calls for veto restraint in what is coined the S5 initiative. S5 stands for small 5, in contradistinction to the permanent 5 members. Our small 5 group of states were Costa Rica, Jordan, Singapore, Switzerland, and Liechtenstein. They called for veto restraint, and they put this into a resolution in 2005, although no vote was taken within the General Assembly. They then put forward a draft in 2012, calls for veto restraint, and a variety of other measures to make the council more transparent. After the decision, this would be a major decision, so it requires a 2/3 GA vote. This is withdrawn. But we do have our 2 most dominant initiatives today, the French-Mexican initiative, endorsed by 105 states, and the Code of Conduct, endorsed by 123 UN member states. And note 123 is almost that 2/3 number there. So almost 2/3 of the UN endorses voluntary veto restraint. The French-Mexican initiative is very significant. Of course, it's led by France. Mexico later joins, and I think it's very significant. One of the permanent members calls for veto restraint. And when we get then to the Code of Conduct, the UK also joins. So then we have a second permanent member. The Code of Conduct is proposed by the ACT group of states. That stands for Accountability, Consistency, and Transparency. And they also call for voluntary veto restraint. And then they call really for all states to pledge not to vote against a credible draft resolution before the Security Council on timely and decisive action to end or prevent genocide, war crimes, or crimes against humanity. So it's a broad call on all states, including those who rotate onto the Security Council, to vote for resolutions calling for action in the face of these atrocity crimes. I will skip over some of the other initiatives. There were ones proposed by a group called the Elders, a group of elder statespersons led by Kofi Annan and Nelson Mandela. There was even a US Genocide Prevention Task Force, bipartisanly chaired by US former Secretary of State Madeleine Albright and US Senator William Cohen. And Hans Corell, who had been head of the UN Legal Office, had his own measures calling for veto restraint. So put together, I think it's clear, for 20 years, the last 20 years, again, there have been calls for veto restraint in the face of atrocity crimes, and nearly 2/3 of the UN member states endorse this, including 2 permanent members. But our problem is, first, these measures are seen as soft law. They're phrased as a code of conduct, a political declaration. And I think this is somewhat unfortunate. In my book, I do examine the hard law legal obligations underlying R2P. So I think we're selling it short. If we consider it all soft law, it is not. There are solid legal obligations underlying R2P. But I think our more significant problem is 3 of the permanent members do not endorse voluntary veto restraint. So when 3 permanent members don't endorse it, we don't have veto restraint. So my book proposes a solution to this, and it basically suggests we need to look at how the veto is being used in the context of our system of international law. So you can think of the veto power as in where it is in Article 27.3 of the UN Charter, but this is really part of a legal system. So the Charter has above it, of course, jus cogens, our highest level of international law. And within the context of the Charter, there are other obligations. And in our system of international law, there are treaties such as the Genocide Convention and 1949 Geneva Conventions. So my book asks, how does the veto interact with the protections we have at the Use-Cogens level? How does it interact with the obligations of the remainder of the UN Charter? And what about these treaty obligations? So I have these three levels of analysis, largely independent arguments. And I'm going to give you the very short version of this, and the longer version is about over 100 pages in my book, entitled Existing Legal Limits to Security Council Veto Power in the Face of Atrocity Crimes, published this year, or published 2020, sorry, by Cambridge University Press. So the first argument looks at Use-Cogens. So we say the prohibition on genocide, war crimes, crimes against humanity are at this very highest level of law. So the veto is found in the Charter, which is then subordinate in the hierarchy of norms to Use-Cogens. So what do we take from this? Well, I would take three things. Firstly, at minimum, it's inconsistent to say the prohibition of these crimes is at the very highest level of the law, and yet you could veto freely regardless of whatever atrocities are occurring. That is at minimum inconsistent. A more aggressive formulation, and I think this is borne out by some of our situations on the ground, is the veto seems to be facilitating the crimes, giving a green light to perpetrators and blocking measures that would be attempting to stop the crimes. So the member vetoing is in some sense somewhat complicit in these crimes. Another way to phrase this is the vetoing permanent member is breaching duties under the Articles of State Responsibility. I look to Article 41.1 of the International Law Commission's Articles on the Responsibility of States for Internationally Wrongful Acts, and these recognize a duty of states to cooperate to bring an end through lawful means of any serious breach of an obligation arising under a peremptory norm of general international law. So the vetoing state party is acting in dereliction of this duty of state responsibility. My second level of analysis looks at the veto found in the Charter within the context of the remainder of the Charter. The Charter in Articles 1 and 2 is framed by the UN's purposes and principles. These include respecting international law, respecting human rights, the obligation of good faith, and the obligation to cooperate in solving international problems of a humanitarian character. Well, I would suggest that current veto use is strongly out of line with these set of legal obligations. And under Article 24.2 of the UN Charter, it states that the Security Council as a whole is bound by these obligations. Now, if the Council as a whole is bound, the individual permanent members can't have any greater power. They don't have the power to violate the Charter's provisions. So when it says the Council is bound, then the individual permanent members are bound as well. Now, also the individual permanent members are bound by the very simple fact that they are states, and states are bound to the UN Charter. My third level of analysis looks at treaty obligations. So I start with the Genocide Convention and the obligation to prevent genocide found in its Article 1. And I also look at Common Article 1 of the 1949 Geneva Conventions, and it's also Common Article 1 in certain of the additional protocols. And all permanent members are parties to the Genocide Convention, and they are all parties to at least the 1949 Geneva Conventions. Now, the ICJ in the Bosnia-Serbia case shows that there is serious content to this obligation to prevent genocide. They say, first, it is triggered by a situation where genocide is at serious risk. You don't need to wait till genocide is occurring. You have obligations when there is already a serious risk of it occurring. They also hold that the obligation is a duty of due diligence based on a state's capacity to influence. So if we think of the capacity to influence of the permanent members, it's particularly strong. Not only are they permanent members, but they often have bilateral relationships with the country in question, and they could use their due diligence. If you have this due diligence triggered by the serious risk of the genocide occurring, the ICJ holds it's not solely an internal obligation to a country to try to prevent genocide within the territory, but an external obligation. They were looking at the obligations of Serbia to try to prevent genocide in Bosnia, an independent state, and they held that Serbia had breached these obligations to prevent genocide. The same analysis basically holds true of Common Article 1 of the 1949 Geneva Conventions. It calls for states parties to ensure respect for those conventions. And the 1949 conventions, of course, contain provisions on grave breaches, one of the subsets of war crimes, and Common Article 3 violations, another subset of war crimes. The Wall and Nicaragua cases of the ICJ, again, say this is not just an obligation for a state to try to respect the Geneva Conventions only in its territory, but to try to get other states also to respect the Geneva Conventions. And the International Committee on the Red Cross in their commentaries similarly describe this as a due diligence obligation that a state has to do what's in its capacity. So you might ask, well, what exactly is required of due diligence? And this is perhaps difficult to analyze, but I would say what we're seeing is really the antithesis of due diligence. When we see a veto, when there is genocide at serious risk, or even veto threats, it seems completely at odds with these obligations. And the same is true of veto or veto threats in the face of violations of the Geneva Conventions, and then certainly the 1949 Geneva Conventions, and for those permanent members who are parties to the relevant additional protocols vis-a-vis them as well. Now, crimes against humanity, of course, don't have their freestanding convention as of yet. The draft that is being proposed does have an obligation to prevent crimes against humanity. This would be fully in line with customary international law obligations, so one cannot yet make a treaty-based argument regarding crimes against humanity, although one can make these arguments based on kind of general erga omnes legal obligations. So my book ends with suggestions. What can states do about this? I argue that states need to take 3 steps. First, they should, at every appropriate opportunity, particularly at the UN, particularly relevant to elected members of the council, or other permanent members, if they sense a veto coming, make these kinds of legal arguments. And states at the UN have already been invoking legal arguments, not just voluntary veto restraint. We see these particularly related to some of the Syria vetoes. We see including, particularly the UK has made strong legal arguments questioning the legality of such vetoes. Other states have done this as well, and states continue to raise these legal questions. States could also work together to put a resolution forward within the General Assembly reflecting existing legal law limits how the veto can and should be used. Or states within the General Assembly could ask the International Court of Justice for an advisory opinion. And they could phrase the question something like this: is all veto use, while there is ongoing or the serious risk of genocide, crimes against humanity, or war crimes, consistent with international law? And they could also phrase veto use or veto threats. So those are possible formulations for the General Assembly to ask these legal questions of the International Court of Justice and bring this forward, that in the UN Charter, there never was a grant to veto regardless of the atrocity crimes. That was simply not done in 1945. It was not done thereafter. And whatever the concept might be in 1945, the UN Charter is a living and breathing document. So we're not necessarily limited to how it was read in 1945. We read it in light of today's obligations. So how is the Genocide Convention read today? Well, we look at the recent holdings by the International Court of Justice and these serious obligations that underlie it. And these are very important for states to take on. And I've also been working with high-level individuals to form a group of supportive individuals who believe this needs to be taken on. And I'm honored to be joined in pushing these ideas by former Undersecretary General for Legal Affairs of the United Nations, Hans Corell, Richard Goldstone, who was the first prosecutor of the Yugoslavia-Rwanda tribunals, former High Commissioner for Human Rights, Navi Pillay, former High Commissioner for Human Rights, Zaid Rad al-Hussein, and many, many others, including Lloyd Axworthy, former Minister of Foreign Affairs of Canada, who is significant in getting R2P adopted in the first place. I'm also joined by a coalition of NGOs who also believe these measures need to be brought forward. So I will end here and take audience questions. Thank you.
Thank you very much, Professor Trahan. Well, as for the questions, I think we do have a couple of them, and I am not very certain as to whether the time will permit us or not, but here you go with your first question. I should let the audience know that we've already had certain questions emailed to us, and this is one of them. To Professor Trahan, what is the antithesis of your thesis, or how would you sum up the potential arguments of the detractors of your thesis?
The detractors. The detractors would be the permanent members. And I don't know where UK and France would stand, because so UK and France have called for voluntary veto restraint. My step goes a bit further and said it shouldn't be a voluntary measure. There are actual legal limits, and I don't know where UK and France would stand on this, given they have been supportive of veto restraint. But I would anticipate the 3 permanent members would not endorse my thesis. I think, you know, that is a given conclusion. Basically, it's realpolitik. They find the veto very useful. I would not expect them to ever recognize there are any limitations on it. But I'm actually not asking for the permanent members to recognize any limitations. My argument is really to states in the General Assembly to take this forward, for the General Assembly to engage with this, to consider working on a resolution, to consider a referral to the International Court of Justice. I do not anticipate the permanent members to be leading this initiative. I think we take our cue from who were the S5 group of states, the small 5. It is probably, the rule of law sometimes is much more enticing to smaller states to take this on. Can be bigger states. Canada spearheaded R2P. So I think it is states such as those that the arguments would appeal to, and not the permanent 5.
Thank you very much, Professor Trahan. We do have another question. It's Farhanuddin. From a lecturer from Brack University. Here's the question. If a veto cannot override the purposes and principles of the UN Charter, just cogence and positive obligations imposed by the Geneva and Genocide Conventions in situations of war crimes and genocide, could this possibly effectively make the veto redundant, considering the fact most situations in relation to which vetoes are generally exercised could be contoured into one of the aforementioned limits? Professor Trahan, I think you need to.
Okay. The veto is sometimes used in the face of atrocity crimes, and so my argument is that it should not be used. I don't think, I haven't done this analysis, I don't think vetoes are only cast while they're ongoing atrocity crimes, so I don't think it's actually, you know, would be across the boards. And of course, when I'm arguing for going to the International Court of Justice, this would be for an advisory opinion. So advisory, it has great weight. It is not technically legally binding, so it actually can't stop vetoes, and it actually can't really change the veto, but I really think it would give added emphasis to this problem and really maybe ultimately force at least the 3 permanent members who don't recognize any restraints to playing a more productive role. And this could actually make a more effective Security Council. The council is not effective when they are just cut off at the knees on measures that could help prevent atrocity crimes. That's not an effective Security Council. Maybe the vetoing permanent member sees it in that country's geopolitical interests at the moment to cast the veto, but overall it harms the UN system and it harms the Security Council. So in the long run, I don't expect them to see it this way. In the long run, it would help even the permanent members to make a more effective Security Council and a more responsive one.
Thank you very much, Professor Trahan. We do have another question, and this comes from Professor Rizwan Islam. There's already a lot of criticism about responsibility to protect, so would realpolitik allow your thesis to be implemented?
Yeah, great question. Thank you. Yeah, R2P, there is great disappointment. You know, we might consider, do we need to rejuvenate R2P? What has happened to R2P? I look at the hard law underlying R2P and say, you know, there's much more to R2P than, you know, calling it soft law. But its fortunes are not doing well. I think it was very much, the Libya intervention was labeled R2P. And then there were accusations, the force authorization went beyond the scope of the intervention. And I think there was just general disappointment. One of the prongs of R2P is the responsibility to rebuild. And that certainly didn't happen in Libya. So it left an unstable state. So I think the fortunes of R2P are not very good. In Syria, we might ask, where was R2P? And I would say it was blocked by the veto. So actually looking at the veto could, you know, help the situations of R2P. R2P has been blocked by politics. The veto is used as a political tool, but I am suggesting it sits embedded in a system of international law. So for too many years have we thought, oh, the veto is just this unlimited thing and can be used, no explanation, no criteria, at will, you know, regardless of what's going on. It really doesn't matter, the atrocities, absolutely unlimited. It's time to stop, you know, buying into that. And as international lawyers, think of the veto within the context of the legal system. So yes, this is in a very political arena, but I'm looking at what can the rule of law say about this political practice, and can the rule of law help us try to rein it in? And I suggest it can.
Thank you very much, Professor Trahan. We do have another question, and it was from a student. Assuming that an advisory opinion is sought from the ICJ regarding the legality of veto on the face of atrocity crimes, could the court be dragged into the terrain of two sensitive matters better reserved for the UN members?
I think I need you to read that again, because I lost a little bit of your connection towards the end. Sorry. No, now you're mute. You're muted right now.
Sorry. Assuming that an advisory opinion is sought from the ICJ regarding the legality of veto on the face of atrocity crimes, could the court be dragged into the terrain of two sensitive matters better reserved for the UN members?
Oh, could the court? Okay, so the court would look at it from a very legal perspective, I think. And I think I'm hoping it would simply look at, well, what does Jus Cogens have to say about the veto? What does the purposes, the principles, the other obligations in the charter have to say about the veto? what do these obligations to prevent, ensure respect for the Geneva Conventions say about the veto? Hopefully they would rule somewhere, you know, there's no guarantee. They could give, we don't know the answer they would give. It could be, if you look at a lot of their rulings, somewhat good and somewhat bad. You know, they often seem to do this. Nuclear weapons, many cases, Kosovo advisory on their declaration of statehood, they don't give maybe 100% of what one might like. You know, certainly may not go as far as I do, but hopefully would say something helpful about limiting this really problematic practice. And hopefully this could then change behavior of states, even if it makes the permanent members just finally all agree to voluntary veto restraint. Who knows where this goes? I'm just a professor. I can't lead this in the General Assembly. It is for states to take this on. And I hope they do. I hope they take these ideas forward. But I don't think it's not asking the ICJ to go in a political arena. Actually, they can't. So if I send a very political question would be dismissed. There is the, you know, the political question doctrine, basically. So you do have to ask the ICJ a very legally framed question. If you ask kind of a political question, I think your case gets thrown out. So it is only a political question. Yes, it operates in a political system, but that is for others to construe what to make of it. They really don't answer political questions.
Thank you, Professor Trahan. I think we would entertain one last question. The ICJ, in its advisory opinion, on admissions to the UN membership, has held that the only conditions mentioned in the Charter should be considered. Nonetheless, permanent members of the Security Council have continued to use veto powers. So would your proposal be practical?
Well, that, you know, that is an older decision. So, you know, I'm obviously going forward in light of the obligations of our international system that we have now. So some of this law has been more recently evolving. So the obligation to prevent genocide, which is also what is at heart in the Gambia-Myanmar case, and we might have some good law coming out of the Gambia-Myanmar case as well. So this is much more recently created law. And a lot of our obligations to respond related to atrocity crimes is much more recent, and a protection of atrocity crimes. Obligations to investigate and prosecute the crimes, which are also blocked when you can't send a situation to the International Criminal Court for referral. You know, these obligations, there's much more law on this today. So I think we would be asking the ICJ now to rule in light of all of these important legal developments, and just to, you know, complete the circle, the harm of the veto threat, and also even self-censorship, because it's known how the permanent members use their veto. No one has even proposed referral of the situation within Myanmar to the International Criminal Court. Bangladesh is, of course, a state party, and this is very significant because crimes, the International Criminal Court has said that crimes that have a cross-border element, if one element of the crime occurs in Bangladesh, these can be prosecuted by the International Criminal Court. But crimes solely internal to Myanmar cannot be. So the ICC cannot, International Criminal Court cannot move forward with these. But just note, we're not even talking creating a Myanmar tribunal, referring the situation within Myanmar, because it is known how the veto is used. So if we can make some inroads on this, then this field of accountability would be far less blocked in these ways. And there are, as I say, obligations to investigate and prosecute these crimes. And these are being violated as well when you have referrals to the International Criminal Court that are blocked, at least where you don't really have other mechanisms that can stand in and do such prosecutions. So I think there are separate problems with the blockage of these kinds of referrals. So it would be incredibly helpful for the system of international justice and ultimately for the victims of these atrocity crimes, if we can make some inroads, because we can't simply keep saying never again, and then it occurs again. And I was speaking last week on a book launch hosted by the Raoul Wallenberg Center, and Erwin Cutler so eloquently linked it to the Holocaust and to the Rwanda genocide and genocide in Darfur and what we suspect is genocide in Myanmar. And the system simply is not functioning. And one of the main impediments is the veto. So I think it really is time to take on this challenge.
Thank you very much, Professor Trahan. It was an absolute pleasure on our part to have actually heard from you. And the chair of the Department of Law, Professor Rizwan Islam, would like to convey his thanks to you especially and everyone who's been listening. I must say that you have a lot of participants who've actually very eagerly heard of you at this time, and thank you very, very much again. And we really hope that you can come back and perhaps talk once again. And for those of you who have missed any part of Professor Trahan's lecture, you will be getting it on YouTube by tomorrow. Professor Trahan, thank you very much once again. And
thank you so much. Thank you very much. Thank you to your university for inviting me. And it has been a great pleasure to speak. And I wish everyone there listening in Bangladesh or wherever you are to be safe. And I invite you to take up these issues in your scholarship and in your life. If there are NGOs who are out there listening, I am forming a coalition of NGOs, and you can find my NYU email address on the website, and I invite you to reach out to me as well. So thank you so very, very much.
Thank you very much, everyone. Thank you, Professor Trahan. Good night.